Hello again, everyone, and welcome back to the Environmental Economics Series, Video 2. Last time we were talking about general ways to value non-market goods and ways to value ecosystem services such as recreation. And today, we're going to delve into a U.S. Supreme Court case that actually touched on these issues and affects how nature lovers can defend the environments they love, and how developers and people with an interest in developing that land can formulate defenses as well. But to look at that Supreme Court case, we're going to need to go back to a year where George H.W. Bush was still the President of the United States, the Soviet Union had just collapsed, and the American rock band Creed wouldn't produce its first album for another 5 years. Get in the time capsule with me. We're going back to 1992 and looking at the Supreme Court case, Lujan versus Defenders of Wildlife. So the facts of the case in Lujan versus Defenders of Wildlife. The U.S. Endangered Species Act was passed in 1973. It's one of the most famous pieces of environmental legislation in U.S. history, and it dictated that species deemed to be threatened or endangered by the Secretary of the Interior in consultation with scientists and so forth would have their habitats protected and would be granted official protection from the U.S. government against habitat destruction, alteration, collection, and so forth. Now, there's always been some disagreement over whether the Endangered Species Act was also meant to apply to U.S. foreign aid dollars, which is to say, can the U.S. government fund a foreign development project, say in Kenya, that the Kenyan government wants to build, a superhighway that they think will improve the economic lot of their people, very impoverished country, but it will go through the heart of, say African elephant habitat. Can the U.S. fund that money, or is that barred by the Endangered Species Act? The traditional interpretation is it applies just to the United States, but many environmentalists think it should and does apply to U.S. foreign aid dollars. In the 1980s, the Reagan administration handed down a rule saying, no, it doesn't, it applies only to the United States, and as a result, America helped fund two projects. One was in Sri Lanka, which is, at the time, and I think still, is home to some Asian elephants and leopards. And the other was the Aswan High Dam along the Nile River in Egypt, which was habitat for the Nile crocodile. The Defenders of Wildlife group sued, and among them were two of their members, a Mrs. Kelly and a Mrs. Skilbred, who claimed, we wanted to go visit Egypt to see a Nile crocodile. One of them claimed that, and the other said, I wanted to go visit Sri Lanka and go see the Asian elephant and the leopard. And because the U.S. giving aid money to these projects is damaging those species' habitat, I am injured by this decision and the inappropriate application of the Endangered Species Act, or lack thereof, to American foreign aid dollars. They asked the Supreme Court to tell the Secretary of Interior at the time, Lujan, thus Lujan versus Defenders of Wildlife, to rescind the 1986 rule from the Reagan administration and say, yes, the Endangered Species Act applies to foreign aid money. We cannot fund these projects. Now, the court's plurality. The plurality opinion was written by Justice Antonin Scalia. Scalia was joined by three other justices, so 4 justices on the whole were part of the plurality opinion, and he ruled that the Defenders of Wildlife, Skilbred and Kelly, did not have what's called standing in the law. And standing means you prove that you're one of the people who is either injured or will be imminently injured by some action of the defending party. And Scalia ruled that Skilbred and Kelly did not have standing because, number one, the Endangered Species Act doesn't apply to foreign countries, but interestingly, for the purpose of conservation of rare species in the U.S., the other parts of his ruling apply to endangered species within our country. And he said that the fact that they did not have imminent plans to return to those countries meant they did not have standing, because, he said, a hypothetical future visit to those countries was not proof that you're among the injured by the destruction of those species' habitat. So basically the court was saying option value that we talked about in the last video is not admissible in court and is not a legal interest. Secondly, said existence value is also not really a legally cognizable interest because the species itself, the animal, doesn't have legal rights. So if the person isn't going to see it imminently and doesn't know where exactly, then the existence of the species is not a matter for the courts to resolve and remedy. So why is Scalia's plurality opinion important? Well, it's important, first of all, because the court's rejection of sort of the ecosystem nexus theory, the theory that I don't have to have an exact location of this animal that's being destroyed. I can say this is their habitat, this is their ecosystem, this is the region where they live. So destroying this is a violation of the Endangered Species Act, means you have to prove the animal is actually there or in very close proximity to stop some sort of development. We ran into an example of this on our trip. We had dinner with a family in South Georgia that we kind of bumped into on the trail. And they were fellow herpetologists, and they told us they had an expressway or a bypass built directly next to their house that they wanted to stop because it ran through their land. And this was in sort of East Georgia. And they were told by the state that even though they had a chunk of old growth longleaf pine, that wasn't good enough. They had to prove not only that indigo snakes and red cockaded woodpeckers might be there, but that they actually are there. And that comes from this Lujan decision. You can't have an ecosystem nexus, you have to prove the species is there, and if this development happens, it'll destroy critical habitat for them. And then the other thing that's important about it is the court, as we said, rejected option value and existence value as interests that can be asserted in court. So as a hobbyist or as a professional or researcher, you can't go to court and say, well, I was going to see a red cockaded woodpecker, a year from now in this coniferous forest, even if you can prove they're there. You have to either have imminent plans if you're a hobbyist, be in the process of seeing and photographing it, or be a researcher who works with that species. And then you have standing to sue in federal court. And the other interesting thing about the locational nexus, and the fact that the court said you have to, pinpoint a spot, basically, is how does that account for runoff? So, for instance, again, back to the salamander world, there's this salamander that lives sort of in central Arkansas, right about here, called the Ouachita streambed salamander. We're hoping to see it in March. And that specific habitat is protected, but what about the land that drains into that stream 1 mile away? And say the government were to okay a permit for some sort of hazardous waste site there, or an industry that was using heavy chemicals, then under this opinion that doesn't fall under endangered species protections. Although that part of the decision has been hotly contested since, and Justice Sandra Day O'Connor and Blackmun's dissent noted that it did not account for runoff. Interestingly, the concurrence from Justice Kennedy and Souter rejected option and existence value, so we're not going to look at that, but the sort of location part of this decision is way too narrow. There should be an ecosystem nexus, or more than just the exact site where the species live, should be the protected area. And then looking at this decision, what hit me is kind of interesting. If you're at all familiar with the Nature Conservancy, what they do is they take membership dues and donations from all around the country, all around the world, and they'll purchase pieces of property that are either at or adjacent to critically endangered species habitat, or just beautiful land. And what you can think about them doing is they're basically saying, okay, the laws of the United States do not permit option value and existence value to be litigated in court and have rights. So what we're going to do is we're going to take a chunk of that option and existence value that exists all amongst millions of people, take that money and purchase property. And now that property gives us legal rights where if someone comes in and collects the animals, we can sue them. If somebody trespasses, we can sue them. If someone wants to develop it, too bad, we own the land. So it's kind of interesting thinking about what TNC, the Nature Conservancy, does kind of from an economic perspective. So anyway, that's Lujan versus Defenders of Wildlife, 1992 Supreme Court decision with a 4-judge plurality opinion, a concurrence by Kennedy and Souter, a separate concurrence by Justice Stevens, and then the dissent by Sandra Day O'Connor and Justice Blackmun. Please let me know what you think in the comments of this series, of this episode in particular. And again, we look forward to the weather getting warmer, filming some herp content for you all. And if you haven't, you should go check out the video of our recent Deep South trip on Bethany's channel, The Herping Lizard. And I want to thank Bethany for filming this episode. Thank you much.